the suggestion made by my senior was that the neck of the ODM party is the aggrieved party. I'd wish to invite the tribunal to have a look at paragraph 4 and paragraph 12 of the statement of claim that is filed in this case. Paragraph 12 in particular contains the course of action, because it is common knowledge that every pleading that originates a suit must have a course of action. The course of action, as contained in paragraph 12, followed by 13, relates to the meeting held by the NEC on 11th of February 2026 and the resolution that followed. That resolution is why we are before this tribunal. If you also look at the prayers, which are, and specifically prayer 1, the complainant seeks to have a declaration that that resolution be declared to be null and void. So therefore, it beats all logic to try and suggest that the NEC is the complainant or the aggrieved party for that matter. Having settled that issue, Chair, in our appeal, we are basically stating that there was non-compliance with Section 42A of the Political Parties Act. It's a well-known section. It has been litigated all the way to the Court of Appeal. And Section 42 and subsection A, as amended in 2022, clearly provides that the tribunal shall not hear or determine a dispute unless a party to the dispute adduces evidence of an attempt to subject the dispute to internal political party dispute resolution mechanisms. The key word is an attempt. And from the submissions that I've had this morning, coupled with the pleadings filed, it is very clear that there was no attempt. In actual fact, paragraph 15 of the affidavit in support of the complaint all to invoke IDRM. There are a whole list of authorities that have been rendered in respect of that issue. I would wish to invite the tribunal to have a look at a case digest. Authority 2, 3, and 4 speak to the issue of an attempt. And in particular, the second authority, which was decided by this tribunal, Chebere and 15 others, versus the National Chair, ODM, this tribunal held very clearly that the amendment that was made in 2022 was made to enhance party harmony and cohesion. It was therefore imperative for this complainant to demonstrate that he made an attempt. And in making an attempt, it does not mean that that attempt has to be considered. That is why that proviso was put in place. So we submit that there's no demonstration of an attempt. We go further to address the issue of whether or not NEC was the final port of call within the party. It was suggested by my learned senior that there was no follow-through once NEC made a decision. I wish to invite the tribunal to have a look at Article 88 of the ODM Constitution.
Article 88?
Yes, 88.
88.
Yes, that article, Chair and members, clearly provides for amicable dispute resolution. And even further, it goes on to say that any dispute that cannot be resolved by party organs shall be adjudicated through arbitration. So in the first instance, members of the party and members with the party organs are encouraged to do IDRM, but where that fails, there's even the process provided for arbitration. The claimants did not pursue the provisos of Article 88, and therefore it cannot be hard to say that there was no room for him to initiate or to follow through on IDRM. There is a recent decision that was delivered by this tribunal on the issue of attempt. It was delivered in November of last year. That is Harrison Abo versus Nicholas Otieno Owaka. And the tribunal was very clear that there's no room for the tribunal to exercise any discretion once it is satisfied that there's no attempt at IDRM. So, Chair, we submit on that issue that there's been no attempt at IDRM. The law is clear. The issue of jurisdiction is settled, going as far back as the case of Lillian S. And we therefore submit that the preliminary objection should stand, and this claim should be dismissed for want of jurisdiction. Chair, in the remaining minutes I have, I'll go to the second issue, which will then be amplified by my colleague, Mr. Mondi, on whether the rights of the complainant were infringed and whether Article 74 of the ODM Constitution was violated. Chair, I would wish to invite the tribunal to go to the claimant's own document at page 82. Starting from page 80, we find the resolution by the NEC. That is why the reason why we are before this tribunal. In an SMS message that was sent via WhatsApp, the agenda was set out for that meeting, and as part of the agenda, it was indicated that there would be a discussion on matters arising. When you look at page 81 of the complainant's bundle, under resolution number 6, the issue of the removal of the Secretary General came under matters arising, which was part of the agenda. It is also important to mention that the SG was given full opportunity to attend that meeting. He chose not to. And in the replying affidavit that we filed at paragraph 5, that is the affidavit of Ali Madaro, we clearly indicate that the resolution of the NEC was subject to the provisions of the party constitution. And that is what the resolution also says. So that our argument remains that under Article 74(3), the complainant had the right to be heard. That right could not be exercised because the complainant rushed to this tribunal, essentially on the same day that that resolution was passed. So we have an instance where chair and members, the complainant does not attempt IDRM at all and admits to it in his pleadings. We have a situation where Article 88 of the ODM Constitution provides clearly for IDRM and also an alternative process of arbitration. We have an assertion made in the replying affidavit that the complainant was to be afforded an opportunity to defend himself. He, however, rushed to this particular tribunal. So in sum, as I close on my arguments, we argue that no final decision had crystallized. If the decision was final, it would have been ratified. It has not been ratified. The internal appellate architecture of the ODM party has not been fully exercised. And for those reasons, we submit that this complaint is premature and is for dismissal. We'll invite the tribunal at its own time to look at the submissions we filed, which are fairly extensive, and the case law that we submitted on the 3 issues that we presented to court for adjudication. So I'll stop there and hand over to my colleague, Mr. Mondi.
Okay, thank you, Mr. Makol.
Thank you, Chair. and the members. Chair, in respect to the question as to whether the complainant's constitutional and statutory rights have been infringed and whether Section 74 of the Constitution has been violated, I want to give brief submissions. My senior, SC Okero, started by invoking some interesting concept of ostrich equivocation tactics by the ODM party, the first respondent. Chair, by the end of my brief submissions, I would hope to have persuaded this tribunal to invoke, expound, and find that the two public policy doctrines, is of ex tupi causa and ex dolo malo no oritur action, basically meaning that no action can arise from a dishonorable cause, and that a based on legal conduct.
Mr. Mondi, I don't know if it's only me, but I seem to be losing you.
I too am having difficulty. Sure.
Yes, Mr. Mondi, just come again from.
Yeah, I was saying that by the end
yes.
of my presentation,
Yes.
I would wish to have persuaded this tribunal that it does invoke two critical doctrines. The first one being the doctrine of ex tupi causa non oritur, that's a Latin legal doctrine, essentially meaning that no action can arise from a dishonorable cause. And the second doctrine of ex dolo malo no oritur, that a court cannot assist one whose claim is based on his own illegal conduct. Chair, I shall be persuading the tribunal also to be conscious of the fact that in crafting the enabling statute, that is the Political Parties Act, number 11 of 2011, that the framers, that is Parliament, had in mind the issue or the aspect of having disciplined political parties that would engage in programmatic competition. The key word is disciplined political parties. Yeah, that is a concept which I honestly believe was borrowed from one of the renowned political economists, Joseph Schumpeter, who really emphasized on the significant role that is played by disciplined political parties in the process of good policy formulation. And finally, I shall be persuading you, this tribunal, that the complainant's conduct is inimical to an ordered and disciplined ODM party, so that the first respondent's National Executive Committee, NEC, had a reasonable basis for initiating the removal proceedings. We honestly submit that the complainant's constitutional and statutory rights have not been infringed or violated. We have demonstrated that under Article 74 of the party constitution, the first respondent had the power to initiate the process of removal, and that the complainant's right under Article 47 of the Constitution, as read with Section 4 of the Fair Administrative Actions Act, of course, read together with Article 74, sub-article 3 of the party constitution, in terms of issue of a notice to show cause, all these rights are intact.
Mr. Mondi, you know that we are recording. The speed at which you are moving is making it bit.
Sorry.
Yes, you could try just to pace a bit. So you were saying that under Article 74 of the ODM Constitution,
ODM Constitution.
Yeah, the process for removal could be initiated by ODM.
By the ODM through the NEC.
Yes.
And that in so doing, the complainant's rights under Article 47 of the Constitution under Section 4 of the Fair Administrative Actions Act that read together with Article 74, sub-article 3 of the first respondent's constitution, that is in turn issue of notice to show cause. Chair, we submit that all those rights are intact. The problem is, and that is our submission, that the complainant jumped the gun and halted an ongoing process anchored in Article 74 of the party constitution, as read with 88 sub-article 3, which we submit lay down a well-layered IDRM process, commencing from the NEC, the NEC, with the option for review or a ratification by specified dispute resolution organs. Those organs are specified that can review or ratify the decision of the NEC. That is the NGC and the NDC. Chair, we also say, I also submit that there is the public interest element in disallowing the order sought by the applicant. And this can be done and demonstrated by the characterization of the conduct of the complainant placed in the context of the organizational structure of the first respondent, which is by far one of the largest political parties in the country, funded by the Exchequer.
Just a minute, Mr. Mundi. Sorry to interrupt. Registry, please help with muting those who are not talking. There's Martin who's making a lot of background noise. And mute if you're not addressing the court. Martin, mute yourself or else we'll kick you out of the platform. Proceed, Mr. Mundi.
Although it's funded by the public exchequer, the affidavit that we filed, and I don't need to belabor the points because it's on record, enumerates instances of infractions by the complainant and if you look at those infractions in totality, if I could just mention a few. For example, the Central Committee holds a meeting on the 27th of October 2025, endorses the position by the NEC, resolving to appoint Dr. Oburu Oginga as a new party leader. The complainant actually reads the resolution. The same complainant subsequently, in quite an array of fora, contradicts the same position. It's just one of the instances of infractions. There are around 6, 7 that we have enumerated in our affidavits. And we are saying that in the context of public interest that is attendant in the office of Secretary General of the first respondent, and my lord, you have to look at this in the context of the organizational culture of the party. If you refer to Article 20 of the Constitution, this is a critical office. This person is the party spokesman, responsible for the management of the National Secretariat, and is a custodian of the party documents. The office is critical for proper functioning of the party. And so we are saying that in view of the stakes, and my lord, when I talk of stakes, we also have to look at it in the context that political rights of the party membership, courtesy of the expanded scope in the Bill of Rights that is enshrined under Article 38, 1B of the Constitution of Kenya, allows participation of members or rather the citizen in activities of political parties. So that when a critical question in terms of the performance of the party secretary general comes into play, it's more than just the individual rights of the person of the secretary general. There's also the question of the millions of followers or the membership of the ODM party. They have a public interest in this issue. And so that we therefore submit that the complainant's infractions as enumerated provided a reasonable basis for the first respondent's National Executive Committee to initiate removal proceedings. I submit in finality that if perhaps this tribunal may proceed to allow the complaint, then you may inadvertently end up enforcing a policy encouraging weak party discipline, encouraging fragmentation of the party system, and that would be contrary to the object of the framers of the Political Parties Act. We pray that you disallow this complaint, and in any case, like we previously, my colleague had submitted, find that in first place, there is no jurisdiction.
Thank you, Mr. Mondi. Mr. John?
Thank you, Your Honor. I hope I'm visible and audible.
Yes.
I have quite a number of things to mention in the few minutes that I have. And my learned friends, with what they have submitted, but I want to recap in a way to emphasize some of the issues that they brought out. The first point I make is that this issue of jurisdiction is not novel. The jurisprudence in PPDT is developed and it's so clear. Just in November last year in a matter in which you were in the panel, Mr. Chairman. You said the following words with some expiration. Additionally, the tribunal has in a long line of authorities considered the various situations on what amounts to an attempt of IDRM. It is imperative that parties and counsel appearing before the tribunal familiarize themselves with the jurisprudence emanating from the tribunal and superior courts of IDRM. You were exasperated because time and again parties have, canvassed this issue before you, and the SG himself, as a practitioner, because in nearly all these cases he has been the one instructing counsels, so he ought to have known and should have known that this issue is key to be able to discuss this issue. Now, in the Madari, this decision is, I would call it, Mewa constituency decision. It is dated. Yeah, you have it on the list, and it is Harrison and others versus Utieno, Nicholas, and Soron. And I want to call it Ndewa decision, Ndewa constituency. Then the next, just the other day, 2 months ago, you had pronounced yourself on this matter, again in the Madari constituency decision, just 2 months ago in January, in paragraph 51 to 55 in the Madari decision. And then even in 2025, in EO 05 of 2025, again springing from Madari, you pronounce yourself. Interestingly, Your Honor, the chairperson has been in all these decisions, and so we are confident on our side that, and satisfied that the tribunal will find that there is no jurisdiction if the complainant has not shown an attempt. But allow me to look at section 40 subsection 2. It is couched in negative but mandatory terms. Have anybody thought about it, that what is the import on how the legislature intended it? For example, it begins with a preposition of notwithstanding. So, because why would he begin with notwithstanding? Shouldn't it could have begun from the tribunal shall not hear and determine the dispute. Now, this notwithstanding itself qualifies, it modifies the whole of subsection 1. And ask yourself why this was. And I submit that it is a very deliberate attempt by the legislature. It is so deliberate, it is intentional. Other lawyers call it for avoidance of doubt. And so you have to show evidence of attempt